A death penalty trial includes a guilt phase, in which the jury decides whether the defendant is guilty, and a sentencing phase, in which the jury decides whether to impose capital punishment. When a defendant is clearly guilty, planning a defense for both of these phases presents a strategic challenge, as we see in Florida versus Nixon. Joe Elton Nixon approached Jeanne Bickner in the parking lot of a Tallahassee mall and asked her to help him jumpstart his car. She offered to drive him home. On the drive, Nixon overpowered Bickner, put her in the trunk, and drove into the woods. There he tied Bickner to a tree with jumper cables and set her on fire. He then drove away in Bickner's car. He confessed to his brother and girlfriend what he'd done. Nixon was indicted for first-degree murder, kidnapping, robbery, and arson. The prosecution sought the death penalty. Assistant Public Defender Michael Corin was convinced that Nixon's guilt wasn't subject to any reasonable dispute. Accordingly, Corin thought the best strategy would be for him to concede Nixon's guilt during the guilt phase to preserve his credibility with the jury during the penalty phase, when he would argue that Nixon shouldn't be sentenced to death due to his mental illness. Nixon sat unresponsive when Corin attempted to explain this strategy to him. At trial, Nixon behaved disruptively and had to be removed from the courtroom. During the guilt phase, Corin acknowledged Nixon's guilt but urged the jury to focus on the penalty phase. After the jury found Nixon guilty, Corin tried to persuade them to spare Nixon's life. The jury recommended that Nixon be sentenced to death, and the trial court imposed the death penalty. Nixon appealed to the Florida Supreme Court. Applying the standard from United States v. Chronic, the court found that Corin's statements to the jury conceding Nixon's guilt were effectively a guilty plea given without Nixon's consent, which amounted to ineffective assistance of counsel. It reversed the conviction and ordered a new trial. The United States Supreme Court granted cert.